Well, I finally figured it out on this Saturday morning with a new filing by Donald Trump's Solicitor General about Lisa Cook and the entirety of our Federal Reserve's independence. It all comes down to the fact that nobody cut off Lisa Cook's building pass. And that's why they're arguing that the Supreme Court should issue a stay to destroy the Federal Reserve because nobody cut off her paycheck and she was insubordinate for showing up to work and participating in the Open Markets Committee to set rates. Are you kidding me? That's what we're down to? Somebody didn't take her building pass? That's the reason you're going to now, you have the entitlement to have the Supreme Court issue you an emergency stay in order for you to gain control of effectively 9 votes out of 12 to set rates in this country? No, not on my watch. You're here on Legal AF. Take a minute, hit the free subscribe button. Money. I'm talking about money. Happy Saturday. Let's dive into it. I got it in my hot little hands and it'll be posted on Legal AF Substack. The final brief. We just had the one from Lisa Cook. This is the final brief in favor of the Trump administration trying to get a stay out of the Supreme Court. Translation, put it into English, Popok. Yeah, they get the stay. That means Lisa Cook is taken out of her job as Federal Reserve governor on the Board of Governors. That means Donald Trump gets the majority on the board. That means Donald Trump fires all 12 of the regional Federal Reserve presidents. That means Donald Trump gets, by doing so, 9 out of the 12 votes to set rates in this country. He's going to lower rates to 1 or 2%, and you'll have to take a wheelbarrow to the supermarket to buy bread. All right, let's dive into the nobody took her building pass argument. So I'm like reading through all of this. Now, I knew they were hurt because yesterday, as I reported, 72 former Federal Treasury and Federal Reserve officials spanning from Reagan to Biden all came out in favor of Lisa Cook, and argued to the Supreme Court in a Friends of the Court brief that they should not allow Lisa Cook to be removed without due process from her job on the Federal Reserve because it will destroy financial markets. Okay, well, that was a pretty good argument. When you have, federal, the following 3 living members who were federal chairs, from Greenspan to Bernanke to Yellen, all telling the Supreme Court, stop, don't do it. The bridge is out ahead. That's pretty compelling. And so that wounded the Trump administration. And so what they said is, no, the financial markets really don't care about whether Lisa Cook is a Federal Reserve governor or not. But my favorite part is when they claim on page, I believe it's on page 11 or so, that no, it's because there was a building pass that wasn't cut off. No, on page 3, sorry. It says the government is also likely to succeed on the merits based on the lower court's impermissible reinstatement. In other words, Judge Cobb reinstated Lisa Cook and put her back in the job. And she participated a week or so ago in the Open Markets Committee meeting to set rates. Here again, Cook declines to defend the lower court's rationale. She does not dispute that reinstatement of officers exceeds court's equitable authority. See, that's a big battle at the Supreme Court. It's going to be coming up in some cases there. Does the federal court have the ability to reinstate federal officers as part of their equitable powers? I don't see why not. They're allowed in other employment contexts to do that, and I don't see how that backs up into the president's Article 2 powers. Instead, the brief continues, she argues that this case, unlike others, involved no reinstatement at all, only a status quo preserving injunction, because no one effectuated the president's removal by cutting off her building access. So now Donald Trump is arguing that because nobody in his administration thought to take away her building pass, give her that little sad cardboard box with a plant in it and all her things and send her packing, that should not stop them from getting a stay now. But the reality is the status quo is she has her job. He says, well, that makes her insubordinate. I fired her and gosh darn it, she wouldn't leave. Right, because you didn't do anything to get her out. In fact, you tried to get her out from Judge Cobb, and Judge Cobb said no. You went to the DC Federal Circuit Court of Appeals in a 2-1 decision. You asked for a stay and they said no. You then waited until after the meeting. You let her participate. Therefore, I think that's a waiver of any argument that you, A, it's an emergency, and B, that you're not disturbing the status quo by taking her out of a job because you left her in the job to vote on the interest rates. They never really explained that. So they say, well, no, it's not our fault. You know, she wouldn't take no for an answer. She wouldn't leave her job. Nobody cut off her building pass. They actually continue that ridiculous line of argument, wasting more time. Cook also faults the government for filing its stay application immediately after, rather than during the Open Markets Committee meeting on September 16th through 17th. But the timing properly accounted for the committee's and the public's interest in avoiding the disruption of an ongoing meeting. It also belies Cook's claim that the removal was conveniently timed to influence that meeting. Come on. It was. They wanted her to vote for interest rate cuts. And it went 11-1, actually all 12 for deep interest rate cuts. But the equally ridiculous argument of theirs has to do with due process. Now, this is what the fundamental part of the case is about. Does Lisa Cook have a 14th Amendment or 5th Amendment due process right, equal protection right or due process right to stay in her job? They argue no federal officer has a due process or property interest in their property. But I beg to differ. The Congress gave her, or anybody in her chair, a 14-year term and said they can't fire her except for cause. Donald Trump says, well, that's just anything I say it is. What's the difference between for cause and at will then? At will is you can fire for any reason. So I don't understand why they would say for cause. If it wasn't, it had to be a legitimate cause that's tied to a due process right. And due process means they make a charge, you get a chance to defend yourself, there's a hearing, and then from there, there's some sort of trial judge that makes an ultimate decision. Not, I think you committed mortgage fraud. They keep saying that as if that's a thing that she committed, when the record does not reflect that. In fact, the record, as will be developed by the trial judge when the case is properly returned to her, will establish that she did not commit mortgage fraud. Yes, she owns 2 homes. Yes, one's in Atlanta, a condo. One is in Ann Arbor, Michigan, a home. She only declares one to be her primary residence. It's the one in Michigan where she declares it for property tax purposes, not the condo in Atlanta. You know, oh, she got a lower interest rate. She got a lower interest rate because that's what the bank wanted to give her. You know, just like banks are trying to make loans. There's no allegation, nor can there be, that she defrauded anybody. You have to, in order for there to be a mortgage fraud, you have to defraud someone. That means the bank or the credit union in this case has to be defrauded. How can they be defrauded when they knew, based on their own records, which Reuters exposed, that she was buying the Atlanta property as a vacation home or second home? How can you be defrauded? They never explain that. They just keep using the words apparent fraud, apparent financial misconduct, as if it were true. If you say it enough, apparently it makes it true. So, I don't find very compelling this argument about that she's insubordinate, right? He says on page 15, Cook's contrary rule that the status quo of office holding should persist so long as no one effectuates the president's removal order. We're back to complaining about the HR department. The HR department didn't cut off her building pass. The HR department didn't effectuate the president's removal order. So now I should have the right to destroy the Federal Reserve. They say that this would encourage defiance and disruptive showdowns. Here, Cook explains that after the president removed her, she ignored his decision and continued to exercise her duties as though nothing had happened. And when the district court declined to issue a temporary restraining order, she continued to participate in the Federal Reserve business. Such conduct amounts to insubordination, another grounds for removal. It has to do with how your conduct indicates that even you didn't think she was fired. That would be the counter argument. Now, look, we're waiting on the United States Supreme Court. Last brief is now in. You know what the stakes are. if he gets Lisa Cook out, now at the Supreme Court level, even if it's temporary for a couple of years, he will destroy the independence of the Federal Reserve. He will take control of the Board of Governors 4-3. He will fire all of the regional bankers. He will appoint his own committee on interest rates. He will cut the interest rates and cook the books, and just like he's done. His fiscal policies, including around tariffs, are failing. And they're crushing the hopes and dreams of the American people. He's cooking the data so that you don't really see it, like the Bureau of Labor Statistics, where he's trying to take control of that. And now we're going to let him put his hands on the spigot of money that was represented by the interest rates. Although, as one of his own, as Stephen Mirren and others on his Council of Economic Advisors have said and had to admit, when you, in every situation where a dictator or a president gets control of the central bank, bad things, short-term and long-term, happen. I'm glad you're here. Saturday morning, Legal AF, take a moment, hit the free subscribe button. Come on over to Legal AF Substack, where I'm doing live reporting like every hour, especially on the Comey issue and the Comey indictment. But I'm glad you're here. I'm Michael Popok. Until my next report. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.